Welcome to the monthly Consumer Issues program hosted by Cornell Cooperative Extension, Tompkins County. On the second Thursday of each month, we're joined by New York State Assistant Attorney General Michael Danaher, who makes a presentation on a topic of consumer interest. Today's program is on consumer rights and responsibilities in the marketplace. After his presentation, Mr. Danaher will answer questions that viewers have submitted to CCE Tompkins in the Zoom chat box. This presentation also will be available on the CCE Tompkins YouTube channel and will be broadcast next month on Mondays on Public Access Channel 15. Thank you for joining us today. And now here is New York State Assistant Attorney General Michael Danaher with today's program.
Thank you, Sandy. Good morning, everyone. I hope that you're enjoying your fall in the southern tier in central New York. As Sandy indicated, I'm Mike Danaher, an Assistant Attorney General with the New York Attorney General's Office in Binghamton. And today's topic we're going to talk about is the consumer rights within the marketplace. We're going to talk about laws that are designed to control the marketplace, because let's think about it. Theoretically, markets are designed to be efficient. That's just straight economics, which is you have a bunch of buyers and a bunch of sellers, and they come together in this thing called marketplace, where the sellers offer to sell and the buyers offer to purchase or accept the offer to sell of various goods and services that are out there. And there are system of economics. The markets are free, meaning that the market itself regulates itself. It's kind of funny as a sidelight. If you ever watch any of the business television, you'll hear the players, brokers, and people involved in it talking about the market. And the market is doing this. And this is how the market responds. Well, the market is really just a bunch of buyers and sellers that are together. It's not a thing other than the makeup of the buyers and the sellers coming together to buy and sell. In the case of the business television, it's stocks and bonds and other types of investment devices. And they all come together, and it's typically to be free. And the play is to bring prices, to bring buyers and sellers together to a price where, and the price would be where they call in economic terms equilibrium, where the price is reached where there is just enough product to satisfy just enough buyers. And that's kind of the equilibrium price. Whereas if the price is too high, the sellers won't get enough buyers. And if the price is too low, there won't be enough sellers or enough merchandise out there because the price is low enough that there's so many buyers that it would take away all the supply. And consequently, the market theoretically and hopefully comes to a point of equilibrium where you have a market where the prices are such that you have an equal number of buyers and sellers. And unfortunately, markets don't always operate efficiently for various reasons. One of the reasons is that in a free market, there are certain assumptions that we make. And one assumption is that all the parties to the transaction, buyers and sellers, have all the facts in order to make a decision or have all the knowledge to make a decision on what they want to buy or sell. And that both parties are kind of an equal bargaining position, meaning that both parties know everything that the product or service will do, and so that they can decide what value that is, and they'll be willing to pay for it. Unfortunately, that's not always the case. All buyers and sellers come into the transaction. The assumption is all buyers and sellers come into the transaction with equal bargaining power, and that may not always be the case. And in some instances, over time, merchants have exploited this advantage they may have about the knowledge of the product or service, that they can use that to manipulate consumers. And so that kind of is the foundation for the rules related to the marketplace. Consumer laws out there are designed not to give consumers an advantage. Some would argue that, well, these rules are so onerous on sellers that the consumers have more bargaining power. It's altered that balance that we talked about before. But really, all the consumer laws are designed to do is to pretty much level the playing field. Merchants frequently and naturally have the upper hand when it comes to the products and services that they sell or offer. One is that the merchants are usually larger. They know what their products or services will do. They know what their costs are, and consequently what they have to sell the product or service for in order to make a profit. And they are the experts in the transaction, typically. We don't hear many instances of stores where consumers are taking advantage of them. Maybe there are some out there, but it's unusual. And consumers are not usually the experts. They might not know what a good deal is from a bad deal. Is this a good price, or is this not a good price? And will it do what I, the consumer, want it to do, or won't it do that? And so the laws out there are designed to actually try to level that playing field. They're not intended to give anyone an unusual or unique advantage, and consumers should still have to be good consumers. They have to utilize the laws that are out there in order to make themselves informed so they can make an adequate and good buying decision. There are many examples out there of the laws in New York that are typically designed to protect the marketplace, to make it more fair. And those are frequently used by our office, the Attorney General's office, in order to assist in enforcing those laws so that the playing field is level to the benefit of the consumers, not to the advantage of the consumers, just to the benefit, so that what these laws do is help the consumer become aware of what it is they're engaging in so that they can make the appropriate decision. Now, if the consumer doesn't use those laws and follow up and investigate what the law provides for them to get, then they're not going to benefit from these laws and they may be disadvantaged. One big law that our office always relies on in our consumer protection initiatives are laws contained in what is known in New York as the general business laws. There's a whole host of them. There's a huge number of laws, articles that fall under the general business law, but they are general business laws, and many of them are consumer-oriented. Many of them are laws that require certain disclosures in different areas so that consumers not necessarily given an advantage, but that they can protect themselves. And one in particular that we hear about always is false advertising. In New York, it's General Business Law, Section 350. Section 350 of the General Business Law provides that it is illegal to engage in false advertising. And that includes, when false advertising is not just something we see on television or something that we hear on the radio. False advertising can be labeling of the product, advertising, any affirmations that are made regarding a product or service. And one thing that we don't think about is that not only does it prohibit false affirmative representations, whether they're in a commercial or on labels or any type of promotional products, but it also could include omissions. So if a advertiser does not include something that would materially affect the buying decision, that omission could constitute false advertising. Some examples might be 50% off the regular price. Now, as an uninitiated consumer, they would think, wow, I'm getting 50%, I'm going to pay 50% less than normal. Well, that wasn't always the case because we've all seen those out there, the ads that there's always 50% off. That means that everybody pays 50% off. So what does 50% off mean if that's the regular price that somebody always pays? So the law prohibits or defines different ways in which the 50% off would be misleading. So if it is not, if the 50% off is 50% off a price that is never charged by anyone, it is not the customary price that the product or service will be offered for in the area in which the advertising takes place, it would constitute false advertising. It has to be 50% off something legitimate. If it is not, consumers, as soon as they say 50% off, they're like, wow, I'm going to get this because it's a great deal. Well, it may be that deal every day, and you could get that same price 2 months from now as you get today. The law says that's false advertising because it is inducing consumers to go out, make a purchasing decision on facts that aren't actually true. There's also laws in New York that prohibit bait and switch. What is bait and switch? Or that would constitute a false advertising where it's baiting you in, drawing you in, and then switching you out. So it could be, let's say, offering a cell phone for $100 off, but they never have it in stock. So you go in and you say, I want this phone for $100 less than what it is. And they say, oh, we're not sorry. Or we're sorry that we don't have that model. But come over here. We have this other model, which of course is more expensive. And that is, they bait you in and then switch you to something else. So in order to prevent that from happening, the retailer must have sufficient amount of merchandise at that sales price in order to meet reasonable demand. So if reasonable demand, you think, well, we'll probably get 10 people in that want that thing for $100 off. You can't just have one of those items. You should have 10. Now, if 20 people show up, it wasn't anticipated the demand would be that high. That'd be a different story. But they have to have a sufficient number to meet reasonable demand. One time, what you will frequently see in advertisements to try and avoid that bait and switch argument is that you may see a notation that says limit of 5 at this price, which would be disclosing to you, say, hey, there's only going to be, to the consumer looking at it, hey, there's only going to be 5 of these things. I better get to the store. And assuming that they did have 5, and you went there and you went to buy, and they said, sorry, we sold out of those, that, again, it was at least disclosed that they have a certain amount available at that price. I would say that having just one item at that price, when they anticipate reasonable demand for the sale, to be significantly more than that would constitute false advertising, because they think that that one item, they can offer one really, really cheap and get in 150 people who will end up buying the item at the $100 more price, just to drag them in. So again, that would be it. Another thing that we see as far as false advertising is cramming options. And what is cramming? Cramming is putting all additional things onto that one item that's being offered. And sometimes we'll see it where an automobile, and again, this would be false advertising. Hopefully we don't see that much in our area because we keep an eye on auto advertising. Let's just use auto advertising where they're offering this great price for a particular vehicle, and you go in and they add to that additional charges, extended warranties, other options on the vehicle, things like that would increase the price of the vehicle. Then that is again, a false advertising, kind of a pulling you in and then adding all these extra things on to increase the price. So again, that law involving false advertising is designed to level the playing field, meaning telling the advertiser you have to advertise fairly and correctly and fully so that a consumer interested in buying that product or service will be able to make a decision that this is something that they want to purchase, knowing all the facts of what may be included. Another general area of law in New York, and it kind of piggybacks on false advertising, is we have a statute in New York that makes it illegal to engage in deceptive and illegal business practices. That's section 349. It comes just before 350, the false advertising statute. It could be that 349 is the general statute that prohibits illegal and deceptive business practices, whereas, or deceptive business practices. And false advertising is a form of a deceptive business practice. Frequently in our cases that we bring, we allege both in a false advertising situation. One, they've engaged in deceptive conduct, and two, false advertising. So such things as representing, in a case that we brought out of the Binghamton Regional Office, was we sued a postgraduate basketball school, which was offering the opportunity to play and practice and increase your skills and play games and get in front of college coaches. And these were for students who had just graduated high school. And so that they were being led to believe that they were going to be offered Division I basketball scholarships, or that the school could link them up to Division I or Division II college basketball scholarships. It's a way to help them defray the cost of the college education. People spent a ton of money going to this basketball school. Fortunately, our office brought a case against this basketball school, which was located in Endicott, and we got an order shutting the business down. But more importantly, just recently, within the last month or two, we obtained a judgment for $380,000 against the business. Don't know if we'll be able to collect it all, but to get restitution for those who were duped into signing up and paying for this program, in addition to getting hit with penalties, civil penalties. We're still in the process of amassing any additional consumers who may have been victimized by this program. We have until the first week in December to submit those additional restitution claims to the court to increase our judgment even above the $380,000. What was happening? Well, they advertised online, and I know our younger people, high school kids who might be looking for opportunities to get to college and may not be able to afford it or want to defray the expense, thinking, well, I'm a good basketball player. I could go to the school for anywhere from multiple thousands of dollars, but typically in the $8,000 to $18,000 range. The prices varied among every individual that went there. They just say, oh, we're going to give you, it's really the price of this program is $15,000, but we're going to be a $5,000 scholarship, which is just, they said, here, give me $10,000 and you can come here. It was a program that ran from October to March. So, $10,000, $12,000, sometimes more for some of our victims, paid thinking, well, if I pay $12,000 now, based on the representations that are made in the advertisements online for this program, I'm going to get a scholarship that will save me much more than the $10,000, $15,000, $18,000 that I'm spending here. And I'll get a college education out of this thing. And so what are some of the things they advertised? They advertised on their website that they provided a college-like environment, that they had top, carefully selected coaches. They had a personal staff member who will assist individually each player with their college placement services. And they had a nutrition program with food preparation by a, quote, top chef, end quote. That and many other things. They advertised that they had a girls program, which they never, ever had. They actually had girls pictured on their website it was called, the name of the business was AAUconnect.com Inc., but they had they used a name called New York International Academy, because a lot of times they were catering to students, prospective students, I call them students, players, that were outside the country. Probably 50% were from outside the United States even. And as it turns out, the accommodations were poor. It did not have a college-like environment. People were housed in apartments. They go and find an apartment building and put part of the team, 4 to an apartment, in an apartment building. There was no college campus. There was no college atmosphere whatsoever. They actually advertised the Broome County Arena as their home court when they very infrequently played there. They never practiced there, or maybe once before. They would rent it out for a weekend, play a couple of games, and that constituted their home court, even though the program went from October to the end of March. They played there once or maybe twice. They used pictures from the arena from when there were big events. So there were large crowds in those pictures. Well, indicating to people, wow, I'm going to play in front of hundreds, if not thousands of people, and that college coaches will be there. Rarely were college coaches there. We've actually had proof that if a college coach showed up, they left by the first half because it was not anything they were interested in. And rarely did they have spectators. There might be parents or family members. There might be 20 people instead of thousands. There were no college coaches. Not one player was ever given a Division I scholarship to play basketball through this particular program. It was just a money grab as far as our office was concerned. So that was a deceptive business practice and false advertising. The court found that and shut them down and awarded us a judgment. Recently, those of you who know, and Ithaca itself, the Attorney General was just there recently. As we taped this, it was yesterday, but as you watch this, it might have been last month. announcing a distribution to local governments, typically, for distribution of the opioid settlement funds. Our office brought a case against opioid manufacturers. Actually, there's a trial that's still going on. Opioid manufacturers and distributors of products that has been a scourge to the United States and in particular New York State. Loved ones died after being hooked on these very, very addictive type of pain relievers. And as a result, some distributors and manufacturers settled with our state, and the Attorney General was out announcing distributions of $1.5 billion of settlement funds to communities to assist in future treatments and help to those who may be addicted to opioids. And that case that's going on now, in the nature of that settlement, was in the nature of a deceptive business practice, representations by manufacturers and distributors that in some instances that it wasn't addictive, or that inducing greater purchases of opioids leading to addictions and deaths, unfortunately, as a result. And so that case was, in fact, part of our office's mission to protect the marketplace and to make sure that these deceptive acts and practices are not continued. Some other examples of general business laws used to protect the marketplace is under one provision of the general business law. There's a regulation of going out of business sales. Well, that's interesting. Why would that be the case? Well, think about it. If consumers hear that a business is going out of business, they think that, hey, they're trying to liquidate inventory. I'm going to get a great price for this particular item. So it's going to draw me in to this store, which maybe I wouldn't go to that store necessarily, but they're going out of business. So I'm expecting this great sale, great prices. Well, some merchants back in the day, prior to this law, would have a going out of business sale all the time. And they would exploit these impressions that consumers would believe when they have a going out of business sale, and end up being able to exploit them to sell these items and reduce their inventory so that they could have the next going out of business sale whenever they needed to have more sales. Well, going out of business sales are regulated. In order for a business to announce that they have a going out of business sale, they actually have to register under the general municipal law with the county, or not the county, the town, the municipal officer filing a record saying we are going out of business. And there are certain requirements. One, that it has to be of a definitive duration, so they can't have a going out of business sale for 6 months. It has to be of limited time and limited inventory. You cannot bring in stuff from outside to keep adding to the shelves to just sell more stuff and more stuff. It's in essence what we consumers would believe to be a going out of business sale, which is whatever we have, we're going to sell. We're not getting in all kinds of new stuff. We're just selling what we have in order to go out of business. And at the end of the sale, the store must close. I had a case many years ago on that exact thing. It was advertising a going out of business sale. Well, in actuality, what was happening is the business was actually moving from one location to another, but within the same community, like the next town over. And they were having this going out of business sale. Well, all they were attempting to do was get rid of their inventory or lower their inventory so that there'd be less stuff to move over to another place where they're going to have another store. And we ultimately settled that they would not do that any further. They had to follow the rules regarding the general business policy. general going out of business sale laws. There's also store return policy laws, which is what are the rules regarding returns of merchandise that you purchase at a store. You think, well, why do we need that? Well, what if you go in and you purchase something and think, well, if the person I'm buying it for doesn't like it or already has it, I can always take it back. And we just assume that, oh yeah, I can just take it back and get it. Well, that wasn't always the case. And what was happening is people were buying things. They would take them back to the store, and the store would say, well, I can't give you your money back. I can give you store credit. I said, I don't want store credit. I just want my money back because I usually don't shop in the store or whatever reason. I just want to have my money back. Well, I'm sorry, that's our policy. Well, they can do that, but it has to be disclosed. The general business law requires that you must post conspicuously at or near the checkout on the item itself and displayed visibly what the return policy is. You must notify, this is the business, you must notify if a receipt is required in order to return the item, whether there are refunds, actual cash refunds, or if it's going to be store credit or whatever, it has to be disclosed. You have to disclose if there's going to be any restocking fees associated with returning the item. And if the return policy is you are entitled to a complete 100% cash refund within 30 days of purchase, then it doesn't have to be disclosed, because if you offer that type of policy, the law says you can, that's good. If somebody's going to return it, they're going to return it within the first 30 days. And if you're offering to take anything back in the first 30 days and give a complete refund, then you're good. But if it's anything other than that, you must disclose what the terms of your return policy are. Why? So that when a consumer goes in, they know what they're getting themselves into when they purchase that product. Not to give the consumer an advantage, but to level the playing field so the consumer knows, when I buy something here, I may only get store credit if I return it, or whatever the policy is. So another, level the playing field rather than just giving somebody an advantage. Because I would be a disappointed consumer if I bought something and I took it back and they say, well, we can only give you store credit, and it's not a store that I purchase much in. And if I was a good consumer and I looked around, I looked near the cash register, I looked up near wherever the checkout is, and saw the return policy and understood it, shame on me if I end up being upset because I get store credit, because that's what the return policy was. The problem is, if I didn't look and I didn't pay attention and I went in and did it, then it's shame. It's shame on me. But if the merchant didn't disclose it, it's shame on them. Another area where we frequently get consumer complaints about when they purchase items is everyone, for some reason, believes that they have a 3-day right to cancel. That is not true. There are typically not 3 days to cancel any consumer transaction. Granted, if you buy goods or services and they have a 30-day, no question asked money return policy, and you get your money back, we don't really concern ourselves with it. But it's usually those bigger ticket items, cars, apartments, home improvements, things like that. We think that there's typically a 3-day business cancellation on an item. Let's say we buy a computer or something, and we think there's a 3-day policy, return policy, and it's not necessarily the case. There are specific laws out there that certain transactions There are 3 business days, but there is no general right to cancel a transaction within 3 business days. So don't assume that you have it, but you may. There are certain exceptions. One is a door-to-door sale. If somebody comes to your house and selling you something door-to-door, you are by law entitled to a 3-day right to cancel. That's the old Fuller brush man that used to come, the vacuum cleaner salesman that used to come to the house and sell stuff. Telemarketing sales. You get a call. They want to sell you something. You say, oh, yeah, I'll buy it. You have 3 business days to cancel that particular transaction as well. And when you think about those 2, the door-to-door sale and the telemarketing sale, the big reason for that is the seller is invading your space, coming to your house. It isn't like you went out to their store and you could walk away. They're in your house. You can't walk away. They're on your phone. Yes, you can hang up, but they're calling you. And so you have that that interruption in your personal space that I think the legislature adopted a statute to protect that situation, at least give you 3 days to cool off to decide whether or not, hey, and I don't really want that. Another area where you do get 3 business days to cancel is a home improvement contract. Home improvement contracts, again, putting a big ticket item improvement into your home, you must be given 3 business days to cancel. And by the way, just to let you know, and we do talk about this in more detail in the sessions when we talk about home improvements, but a word of warning to everyone, that 3 business days, 72 hours, goes by really quick. So you have to make your decision pretty quick. So 1, don't make the decision to buy something if you're trying to rely on a 72 hours to think about it. Think about it before you sign the contract. Then you don't have to worry about canceling anyway because you never signed it to begin with. But it can go by very quickly. And so you may not think about it for 4 days, and by then the 3 business days is over. So be aware. Health clubs, you sign up for a health club membership, you get 3 business days to cancel the transaction. And other types of things like loans, home equity loans, things like that, the law provides that you have 3 business days to think about that transaction before you can really, well, in order for you to cancel, you can cancel those if you want. My advice, though, is the best thing to do is to be a good consumer in the marketplace. 1, know who you're dealing with. Verify who you're dealing with. Don't take them for their word. Although these laws are out there to help level the playing field to limit false disclosures, fraudulent business practices, we have to be good consumers. We have to know who we're dealing with. And that's especially true now with the internet. Be very careful about the use of the internet. Know who you are dealing with when you are buying goods and services over the internet. Try to verify who it is. Deal with people you know. Deal with companies that you've dealt with before. Be wary of reviews that are on the internet. There are some instances where those reviews are not legitimate and that they've been posted by others who in some instances are getting paid to post reviews. So don't rely solely on that. Look at them, get an idea, but try to do your due diligence to figure out whether this business is legitimate or not. Get references from people that you trust. If one of your friends had used a particular business to do something or sell them something and they had a good experience, that's good. Get multiple estimates if you're going to have work done or anything. Get estimates for how much it would cost to do this. Do not pay by sending cash. Protect yourself. My advice, use a credit card. Credit card, if you don't get the item, you can challenge the charge against your credit card. You could challenge a payment that you made from your bank account, but at least in that circumstance, you had actually sent your money out and you're trying to get it back. With a credit card, the credit card is really a loan. And so it isn't your money that's being used, it's money that's being loaned out by a financial institution. And that you can challenge that quote loan if you never got the item that, or the item that came was not what was portrayed. Make sure you know and understand all terms, such as warranties. What are these warranties? What do they cover? What do I have to do to claim a warranty? Understand the return policy. Know what the return policy of the store is. Again, it should be posted at or near the checkout conspicuously, so you should be able to view that. Know whether or not you're being signed up for other offers. So you signed up for this subscription, but they added all these other things on. Usually I've seen is a short period of time for 3 months. You get an additional magazine subscription or something. Next thing you know, you're getting a bill for the magazine because you didn't cancel within the 3 months that you were supposed to cancel. So be aware. If you don't want these add-ons, don't even sign up for them. When they say, oh, we're going to give you a complimentary offer, you can say, no, thanks. No, thanks. I don't need the 3 month subscription because I don't want to have to cancel it. So do not give that to me. I do not. Do these sorts of things and you go a long way toward protecting yourself. The general business law in New York covers a whole host of different categories. It's really, really long. Some other examples are the law requires that if a business is or individual is operating in anything other than their own name, they must file a business certificate. An assumed name certificate should be filed in the county clerk's office where the business is operating, because people need to know who they're dealing with. So if you're dealing with an individual, John Smith, but you don't know that, you think you're dealing with XYZ home repair, and all of a sudden there's a problem with the home repair and you can't find XYZ. You should be able to go to the county clerk's office and look up XYZ home improvement and find out that John Smith had filed a doing business certificate, and it should have his name and address so that if you do have to sue him or do have to find him, you'll be able to do that. If a business is operating, or individual operating under a name other than their own name, they are in violation of law unless they have filed an assumed name certificate. There's laws governing truth in travel. There was a problem with offers of travel, excursions and things like that, but there's laws that cover disclosures, particularly in that field, and that field also would include timeshares, where people are selling timeshares, and there have to be full and adequate disclosures. Employment agencies have to be licensed. People who are offering silver, gold, and diamonds for sale, there are actually rules regarding what the quality or the consistency of that gold or diamonds or silver is. There's all types of things in the general business law, again, to level playing field. So we have to act like good consumers. We have to use these laws to our benefit so that when we go in, we know what we're getting ourselves into and that we're protected, so that when we do make that buying decision, we hope that it's the best thing for us and that it's fair and it's reasonable. If there are any questions, I'll be glad to answer those questions. If there are not any questions, I'm going to hand it back to Sandy, and she could do our wrap-up.
Thanks, Mike. I'm not seeing any questions in the chat. Thanks to those who joined us today for this presentation. Mr. Danaher will be back with us on Thursday, November 11th at 11 a.m. for a charitable giving update. You can find the Zoom link on the event listing on our website at ccetompkins.org/events. Hope everybody has a good day and a good weekend.